The Leader of the Opposition.
I lead for the opposition on the Mining and Petroleum Legislation Amendment Bill, and I can indicate that the opposition does not oppose the legislation. The object of the bill is to amend the Mining Act 1992, the Mining Regulation 2016, and the Petroleum Onshore Act 1991 to clarify how those activities, which are now known as mining purposes, to be called ancillary mining activities in the future, are carried out in connection with mining leases and are regulated under the Mining Act. For example, the bill before the House will permit the consolidation of multiple ancillary mining activities into a single mining title. At present, you may have a primary mining title and then multiple and indeed separate titles regulating each individual ancillary mining activity taking place in conjunction with the primary mining operation. These are typically to do with tailings dams, stockpiles of displaced soils and other works. And this is to make sure that they can all be consolidated into the one title and regulated more simply. The bill also makes further provision in relation to the giving of enforceable undertakings under the Mining Act and Petroleum Act and the enforcement of those instruments. For example, it requires those undertakings, including any variations made to them, to be published publicly. It will enable the Secretary of the Department to apply to the Land and Environment Court rather than the District Court for an order if a person contravenes an enforceable undertaking under the Mining and Petroleum Acts, whether or not proceedings have been instituted for an offence for the contravention of the enforceable undertaking. At present, Mr Deputy President, if the Court is satisfied that the person who made the enforceable undertaking has contravened the undertaking, the Court, in addition to imposing any penalty, may make orders directing the person to comply with the undertaking, an order discharging the undertaking and any other order the Court considers appropriate in the circumstances, including orders directing the person to pay to the state the costs of the proceedings and the reasonable costs of the Secretary in monitoring compliance with the enforceable undertaking in the future. The legislation before the House adds to that and makes it clear that those applications can now take place in the LNE Court, not just the District Court. A rare example, perhaps, Mr Deputy President, of this government taking a jurisdiction from a generalist court of a lower stature, such as the District Court, and giving it to a superior court of record, equivalent to the Supreme Court in the LNE Court, and giving its specialist jurisdiction, a bit like the reverse of the work health and safety jurisdiction being taken out of the Industrial Court and sent down to the District Court. A little irony there, Mr Deputy President. The legislation also permits proceedings to deal with breaches of enforceable undertakings to be dealt with summarily in the Land and Environment Court, of course. That's a very sensible provision to make clear. The legislation makes further provision in relation to offences under the Mining and Petroleum Acts regarding the furnishing of false or misleading information. It significantly increases the penalties and makes them consistent with offences under the Mining Act, Petroleum Act, the Protection of the Environment Operations Act and the EP&A Act and the Biodiversity Conservation Act by increasing penalties against individuals from $55,000 to $220,000 and against a corporation lifting the penalty from $110,000 to $1.1 million maximum penalty. And so we welcome that aspect of the legislation. The legislation makes other miscellaneous amendments regarding the administration and enforcement of each of the Mining and Petroleum Acts. I note that all the relevant stakeholders in the sector appear to have been consulted. The Minerals Council and the Construction, Forestry, Mining and Energy Union Mining Division. I think the Minerals Council aren't that happy with aspects of the legislation, but not so unhappy that they would oppose it. We have no difficulties with the legislation before the House.